Hello, everyone, and welcome back to the Employment Law Counselor Podcast. I'm your host, Jeff Stewart, and each and every episode, we tackle the laws and regulations that make up the world of labor and employment law. Today, we're going to do part 2 of employee handbooks. As always, I'm joined by one of my colleagues here at White & Williams to discuss our topic of the day. Today, I'll be joined by Laura Corvo, who practices out of our Newark, New Jersey office. How are you doing today, Laura?
I'm doing great, Jeff. It's great to be back with you.
Thanks. I'm glad I didn't scare you away after the first episode. So welcome back.
Thank you. Like I said, it's good to be back, and I'm happy to tackle this second part of our series here.
So last time we talked about employee handbooks and a general overview. And if you haven't listened to that episode, please go back and find that and listen to it. But today we're going to be talking about common mistakes in employee handbooks and what can get you into trouble and how to avoid them. Which is always an interesting area and an interesting topic. So, Laura, let's jump right in here. I mean, when I think employee handbooks, I think, well, they are, for lack of a better term, an essential tool for businesses in defeating claims that an employee may bring. But you and I have seen a lot of employee handbooks, and we've seen ones that are drafted very well. And then we see ones that, frankly, cause more problems than they're worth. And this podcast is meant to highlight those mistakes and learn from other people's mistakes so that hopefully our listeners, their businesses, don't encounter the same mistakes. Or if they have them, if they've made those mistakes, they can correct them. So let's jump right in. Laura, what would you say is the most common mistake that you see an employer have with their employee handbook?
I think the most common mistake is the employee handbook says one thing, but the employer does another. The employer has either downloaded an employee handbook off the internet without realizing what its policies say, or it hasn't updated its policies after changes, and it promises something to an employee that it can't deliver because it's really not their policy. It's not customized to that employer.
Absolutely. I'll give an example that I saw in a sex discrimination case where the employer had a policy that said if two employees marry, that the one with the least seniority gets moved to another department because they did not want married couples in the same department. Well, in fact, they did the opposite because they said, well, the junior employee is more important, and therefore we're going to tell the more senior one that they need to leave. And, oh, by the way, we don't have a job for you now. We don't have a place to transfer you, so we're just letting you go. Well, obviously, the employee who was female said, wait a minute, that you're not even following your own policy. And I think you just wanted to get rid of me, and this is actually sex discrimination. And that led to, frankly, a lawsuit. That's an example of having one policy that says one thing and doing the opposite. And in fact, Laura, I think you'd agree with me that when you have a policy that says one thing and you do another, what you're really doing is giving the employee evidence of pretext, which in a discrimination case is how an employee wins the case. Would you agree with that?
Absolutely. Once you have a policy, you have to consistently enforce it across the board. So if you have a policy and you don't follow it, it's actually more harmful than not having the policy at all. Because as you said, Jeff, that could be evidence of a pretext for discrimination. It could also be evidence that, you knew you were supposed to do it, but you're not doing it. So it's really important that, your handbook actually says what you mean it to say.
Absolutely. And also, if you end up in a lawsuit and it goes to a jury, you are going to look terrible. I mean, just from a practical standpoint, a jury is going to sit there saying, well, you wrote the policy and then you didn't follow it. You had control over the policy and you did the opposite. So why should we believe you on anything? And from a practical standpoint, that is a major, major problem.
It's probably the biggest blunder most employers make when it comes to handbooks, because they either don't know their policy, they don't understand them, or they haven't updated them.
Absolutely. And that actually transitions nicely to our second most common mistake, which is the handbook policies have never been updated to fit the current workforce. And when I say that, just a common example is, let's say you have a policy and your company has been growing and you have a leave of absence policy that maybe allows for, up to a 4-week leave of absence. But you went over that 50 employee threshold where now the FMLA, the Family and Medical Leave Act, applies to your company because you have 50 employees, but you have no FMLA policy. And in fact, the policy you do have on leaves of absence is not consistent with the FMLA. You've got a problem.
Yeah. You will have problems where the employer has changed because, as you said, maybe you've grown and now you're suddenly subject to things like the FMLA or other or laws because of the number of employees you have. The laws around you have changed. A sick leave law has been introduced in your state or your city, and you suddenly have to offer more sick leave to your employees or offer it in a different manner. Or you have a policy that says you don't allow employees to carry over sick leave from one year to another, but the law says that you have to permit employees to do that. So, you haven't changed with the laws, or you've changed your internal policies. Maybe you're changing the way your vacation is handled, but you haven't updated the handbook to reflect that policy. So all of those things, I think, can get you into trouble and create inconsistencies employees can find when either they file lawsuits or claims against you.
Absolutely. And the other area where, maybe you as an employer have changed is maybe you've now crossed state lines and you need to have assurances. You need to make sure that your policies follow whatever states you're operating in. There is not a one size fits all.
Yeah, and I think a lot of employers may not even realize this post pandemic as more employees are beginning to work remotely. You could find yourself in a situation where, you maybe had employees working in just one or two states. And as people work remotely and have moved out of the state, suddenly you're subject to laws in other states you may not have even been aware of. And your handbook policies have to reflect that.
Now, the other common mistake that I see a lot, and I know we talked about it a little bit in our last episode, but I think it is so important that we need to take some time to mention it here again, is if the employer fails to collect that acknowledgement page from their employees. Now, that acknowledgement page, just as a refresher, is usually the last page in the handbook, and it says something to the effect of, I, the employee, have received a copy of the handbook, have had an opportunity to read it, I understand it, and that I understand that it is my responsibility to abide by the policies in that handbook. Then the employee signs and dates it to show that they actually received a copy of the handbook and that they're responsible. So if the employer has not collected that acknowledgement form, they cannot prove it, whether it be in court, in an unemployment hearing, or elsewhere, that the employee was on notice of those policies. And I definitely see that as an area where, frankly, employers can improve because you have control over that.
Yeah. Oftentimes you will see an employer have a great handbook with great policies that, as lawyers, we want to use in the litigation to defend the employer, but they don't get the acknowledgement from the employee that the employee received it. And at that point, it's kind of like a big letdown for us because, the ability to use that policy as a shield for the employer becomes significantly diminished.
Absolutely. So I'll say the fourth of the common mistakes that I see is an employer who got their handbook off the internet. And I know you and I have both seen this. And, as attorneys who draft employee handbooks, it's one of our pet peeves, frankly, is the cookie cutter handbook off the internet. But the reason this becomes a problem is that cookie cutter handbook almost never discusses local laws that you may be subject to, or it actually states policies that might be in conflict with state or local laws. And that just leads to all kinds of potential problems, whether it be wage and hour, whether it be disciplinary, wherever it is. That handbook that, hey, it may have been $150 online, or maybe even you got it for free. Well, frankly, it's terrible and will get you in more trouble than it will protect you from.
Absolutely. This is one of my biggest pet peeves when employers come to me is they download these handbooks off the internet without really understanding what they say, or the handbooks off the internet are not designed for the industry in which the employer's operating in. I've seen employers with 10 employees have an FMLA policy, which would only be applicable to employees with 50 or more employees. And then some of the policies, go on for pages and pages explaining statutes and case law and citing to things that really doesn't need to be in the handbook. And then, you'll also see something where you have employers who's in maybe a manufacturer who has policies that really belong in a retail handbook. When we get our handbooks, we try to customize them to where you are locally in terms of which laws you need to follow, who you are, businesses you do, and then we look at the specifics as to, who your employees are, so we know what laws and what policies have to be in there, what applies to you. And without that little customization, the handbook is really useless.
Absolutely. Absolutely. And that is my biggest pet peeve. And like I said, it is an area where I find employers who are trying to be responsible end up not responsibly dealing with the issue because they're trying to save a few dollars on the front end, and it will end up costing them literally tens of thousands, if not hundreds of thousands of dollars on the back end because they simply didn't take the time to get a proper handbook and to keep it updated. So, the last of the five, I'll say, most common errors in a handbook that I see is a handbook that doesn't specifically address harassment issues. Do you see this as well, Laura?
Yes, I see it in terms of not having a harassment policy is a big faux pas in terms of handbooks. But even if you have a harassment policy, that harassment policy has to address all forms of harassment, and has to have a complaint procedure. There's certain things that have to be put into a harassment policy that really a lawyer needs to take a look at to make sure that you have the adequate defense you need if you're going to be sued in a harassment type situation.
Let's talk for a minute about that complaint procedure because that's an area that I see as usually the most problematic. Because if you have a sexual or harassment policy or any harassment policy, because as you said, Laura, it's not just sexual harassment, it's could be religious harassment, disability harassment, racial harassment, but any harassment policy. If it says, look, if you have a problem, go to your immediate supervisor, and then that's the end of the complaint mechanism, I'll tell you that your policy doesn't work. Your policy is going to be deemed ineffective because who is the most common person to be harassing an employee? Frankly, it's their immediate supervisor. So if you don't have a way to go beyond the immediate supervisor, your policy is going to be deemed by a court of law as ineffective. So I always tell people you need to have ideally a three-level complaint mechanism, which is you go to your immediate supervisor. If you're uncomfortable for any reason going to your immediate supervisor or you're unsatisfied after going to your immediate supervisor, then go to whether it be the director of human resources or some similar title. You go to that person. But if you're not satisfied after raising the complaint there, or you're uncomfortable with for any reason bringing it to that person, then go to the director of operations or the president of the company, or that third level, which is usually a top level of the company, to allow any employee who's experiencing harassment to have some avenue, have some way of raising that complaint and being heard. Because if you just say take it to your immediate supervisor without having any alternatives, frankly, that is not effective.
Absolutely. And also in defining harassment, what it means to be harassed. The laws change as to what constitutes forms of harassment. Maybe 15 years ago, a lot of employers updated their sexual harassment and other harassment policies to include the exchange of emails, the fact that harassment can be done by emails. Well, now it's text messages, social media, things like that. as times change, you have to update those policies and explain what harassment means. And that's going to change based upon the world we live in, as well as the laws, especially the laws in the states that you're operating in.
All right. So that was really our 5 most common mistakes in a handbook. It was the policy that says one thing, but the employer does another. The handbook policy that's never updated to fit with the current workforce. The failure of an employer to get that acknowledgement page. The cookie cutter handbook that was off the internet that doesn't address everything that's necessary for a particular employer. And then finally, the handbook that does not properly address harassment issues. So, Laura, as you know, I like to give our listeners a few takeaways at the end of every episode. So, what would be your number one takeaway?
Well, I think the number one takeaway is to update your handbooks regularly to make sure that they say what you mean them to say and what the law requires them to say. To make sure that the policies that are in them are actually the policies that you're following as an employer, and that those policies are compliant with the state, local, and federal laws that you're going to be subject to. And that's not just something you do every 5 years. I mean, I recommend that employers visit their handbook at minimum every 2 years, and ideally at least once a year, or when there are major policy changes that come down because of different laws. But this is something that shouldn't just be you develop the handbook and then 10 years later you look at it again. It should be a constant modification. And that modification is not something that's a great undertaking. It's something that can be done relatively quickly, but you just want to make sure you actually review them, update them, and as I said, that they say what you mean them to say.
Absolutely. And I think to piggyback on that, if you do reissue the handbook, et cetera, get a new acknowledgement page.
Absolutely.
And make sure you're vigilant on making sure everyone signs it. I think my top takeaway would be that there is literally no such thing as a one size fits all handbook. Every company is unique, and you as an employer need to make sure that your handbook reflects your business, because I'm not going to have the same handbook for a construction company that I do for a busing company, that I would for a mortgage company, that I would for a human services company. All of those businesses are very different, and the expectations on employees are very different. Now, they may all have similar policies as far as how much vacation they offer, or that there's an expectation that people come to work on time. I'm not saying that no policy would be the same, but there are going to be differences, and you need to make sure that your handbook reflects those differences and reflects your company.
That's a great point, Jeff. Whenever I do a handbook, I like to have an intimate conversation with the employer to really find out what their business is all about, who they are all about, so that all of that can be reflected in the handbook. There's no magic form that we just print out on our computers that just spits out every time a client asks us for a handbook. There is a customization that goes into these. And it's that customization that's really going to give the employer the effective tool it needs to establish that relationship with its employee going forward, and to use as a potential shield in claims that the employee may bring.
Absolutely. Well, Laura, I thank you once again for your insight here in this world of employee handbooks. I know between the two of us, we've probably drafted a few thousand employee handbooks over our careers. So I'm happy to share this knowledge with our listeners here today. So thanks for joining us on the Employment Law Counselor podcast, where we try to make sense of the world of labor and employment law. On behalf of myself and Laura Corvo, we thank you for listening. If you enjoyed this episode, please leave us a 5-star review, tell your friends, and subscribe to the podcast. For more information on this and many other topics, please visit our blog at www.theemploymentcounselor.com. Our next episode is going to be dealing with OSHA, where I'll have John Baker from our Lehigh Valley office. And we'll be talking about what to do when OSHA comes knocking at your door. Until next time, stay safe and stay compliant.